recite our congressional motto so earnestly, but it's always inspiring to be able to share it with you and with America. Ladies and gentlemen, lots of exciting things going on at the Constitution Center. As always, for those of you who haven't visited it yet, please allow me to exhort you to rush to the new American Treasures Gallery. It opened last week, and this is the first time ever in American history that the 5 rarest drafts of the US Constitution have been displayed in one place. Not even during the Constitutional Convention itself were James Wilson's 2 original drafts of the Constitution displayed next to the Committee of Style report and the first public printing of the Constitution. It's all in this amazing gallery, which is just to the left of the Kimmel Theaters or downstairs. There's no sign, so you really have to be in on the secret in order to know that these treasures are there. But it's just so thrilling to be able to look at Wilson's drafts. And today, here's the digital hook, we just launched this great web link, which you can find at constitutioncenter.org/treasures, where you can literally click on each draft of the Constitution and compare its evolving text and see how the preamble, for example, evolved from "We the people of the states of New Hampshire, Providence and Rhode Island plantations, and Massachusetts and so forth," to "We the people of the United States," signaling Wilson's belief that we the people of the United States are sovereign rather than those of the individual states or of the British Parliament. It's an amazing online experience, and please check it out. And next month, later this month, May 24th, come back for the phenomenal opening of a John Marshall exhibit, which includes not only the desk where John Marshall wrote Marbury versus Madison, but as I mentioned to some of you before, John Marshall's gallstones obtained from the Mutter Museum, which I actually fainted when I went to the Mutter Museum the first time. I was with my kids, but you can faint with constitutional pleasure when you see Marshall's gallstones reposing happily here in Philadelphia. Dr. Physic removed them, the famous Dr. Physic, and he almost died, but thank goodness the great chief succeeded and the Constitution flourished. We're here for a very special event. Not long ago, Microsoft came and asked us to bring the best scholars in the country of different perspectives to ask one of the most central questions of our time: how can we translate the Constitution to protect privacy in a digital age? And I want to thank and acknowledge Catherine Youssef, who's the Director of External Relations at Microsoft and who's here, and we're so grateful to them for convening these scholars. And we didn't give the scholars any homework except to answer different aspects of the problem and try to think of how to preserve the same amount of privacy in the age of cloud computing as the framers took for granted at the time of the 18th century. I'm going to set up this show, which will be ably moderated in a moment by Tom Donnelly, our superb senior fellow for constitutional studies, who oversaw the project and helped to edit the papers and will moderate the discussion. But I'm going to introduce it, because I care so much about it, by asking my favorite question, WWBD. What would Brandeis do about the problem of privacy in the digital age? And it's a very exciting question to ask because Brandeis thought more deeply about how to translate the Constitution in light of new technologies than any other justice of the 20th century. So let's move back in time to the year 1928. And it's the heart of Prohibition. And you can learn more about Prohibition at the incredible Prohibition exhibit downstairs, which, as it happens, by happy coincidence, and it is a coincidence, although there's always more, there's some sort of divine force that oversees all of the Constitution Center's activities. But we have in that exhibit the phone that was at the center of the most important electronic privacy case of the 20th century. And that phone belonged to a bootlegger called Roy Olmstead. And here is his story. Roy Olmstead was one of the most successful bootleggers of his age, making millions of dollars in 1920s money by importing illegal booze from Canada and British Columbia to the US. And we know from the exhibit downstairs that Prohibition gave rise to the most important controversial constitutional controversies of the 1920s. Just as the war on drugs is the source of all the constitutional law cases that I teach from the 1980s and 90s and 2000s, so the war on booze was the center of the constitutional dramas of the 20s. And what's so interesting about the Prohibition exhibit is that its effects were predicted by, I have two heroes, because I just finished a book about Louis Brandeis and I'm now writing one about President William Howard Taft. And Taft, before he became Chief Justice, predicted the constitutional effects of prohibition. He said, this will be a disaster. It will be passed by mobilized minorities against the wishes of majorities in many states. If passed, it will lead to sweeping federal laws that criminalize activities that used to be left to the states. There won't be enough federal agents to enforce the laws, and therefore the distribution and manufacture of booze will be taken up by criminal gangs. The courts will be clogged, disrespect for the law will be rampant, and these laws will be so unpopular that eventually people will not respect them, or prohibition may even be repealed. He's completely prophetic about the effects of prohibition, and you can see this all play out in the exhibit downstairs. But then the 18th Amendment passed, and Taft, as a true constitutionalist, said, okay, the people have spoken, I need now to enforce it. And as Chief Justice of the United States, he presides over a series of cases that actually uphold the prohibition laws, even though he thought they were a bad idea as a policy matter. So the central case in prohibition, and indeed the central privacy case of the 20th century, is called the Olmstead case. So this guy Olmstead, whose phone you can see downstairs, is calling up his cohorts in Canada and arranging for the importation of this illegal booze. And federal agents suspect what he's doing, and without a warrant, place a wiretap under the sidewalks that are leading up to his office. And they listen in on his phone conversations, and they conclude that he is indeed a wild bootlegger, and they indict and convict him. He objects that the conviction is unconstitutional and a violation of the Fourth Amendment to the US Constitution, which says the right of the people to be secure in our persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. And Olmstead claims that the search of his electronic conversations without a warrant is unreasonable and unconstitutional, and the conversation should be excluded. In a majority opinion, a 5-4 majority opinion, Chief Justice Taft rejects the claim. And it's a very straightforward opinion, and it's not terribly creative, but it's easy to explain. Taft says, at the time of the framing of the Constitution, you needed a physical trespass into private property to trigger the Fourth Amendment. And indeed, the central drama that triggered the American Revolution were the general warrants and writs of assistance, which authorized the king's agents to break into the homes of people who were suspected of violating the hated tea tax laws in Boston, for example, or of writing pamphlets criticizing the king in England, and of arresting them for their seditious thoughts and violating the privacy of lots of innocent people because the king's agents were able to invade private property of the home. And Taft said, here there's no trespass because it's a public sidewalk. They didn't break into his office, and therefore no trespass, no violation. Very straightforward, but it defines the law of privacy based on the laws of property, and that's why Olmstead lost. Brandeis dissents, and it's the most beautiful privacy opinion of the 20th century, and please read it after the show, not now, of course, because I'm talking, but just go to Olmstead versus United States and reads Brandeis's dissent. So this is a amazing dissent because it's 1928, and Brandeis has in his desk a clipping about a new technology, television. But he misunderstands television. He thinks it's a two-way technology where people can see each other through both ends of the camera. Basically, he anticipates Skype and webcams. And his law clerk, whose name was Henry Friendly, who later became a very famous appellate judge, says, you can't just look out of a television camera and see someone on the other side. Now, of course, you can. So Brandeis omits the reference to television explicitly, but he refers to it implicitly. And in this prophetic opinion, and Brandeis was a prophet. It's really important for me to convey this to you, that he was prophetic in anticipating the evolution of technology and insisting on translating the Constitution to take account of it. And in this amazing passage, he literally looks forward to the age of cloud computing, where documents can be stored in distributed third-party servers, not literally, but metaphorically. And he also anticipates mind-reading technologies like fMRI technologies that can peer into our brains and reveal our unexpressed thoughts, sensations, and emotions. And here, in effect, is what Brandeis says in this amazing dissent. He says, the progress of science is not likely to stop with wiretapping. Ways may someday be developed by which it's possible, without physically intruding into desk drawers, to extract secret papers and introduce them in court. Advances in the psychic and related sciences may make it possible for the government to reveal unexpressed thoughts, sensations, and emotions. At the time of the framing of the Constitution, Brandeis said, a far smaller intrusion, the general warrants that sparked the American Revolution, were held to be illegal and unconstitutional without probable cause. We need to translate the Constitution. Can it be, he said, that the Constitution wouldn't protect us against even greater invasions of individual security? So it's remarkable both in its prophetic power seemingly to anticipate an age in which private papers will be stored outside the home and in which the mind can be invaded without physical trespass, but also in its repudiation of formalism. Brandeis is saying, don't focus on whether there was a physical trespass, focus on the value that the framers were trying to protect, which was, as our scholar in his white paper, Neil Richards, argues, intellectual privacy. That was the value, said Brandeis, that was threatened by the general warrants that allowed the king's agents to read private diaries and anonymous pamphlets criticizing the king. And in order to protect intellectual privacy in an age when it can be invaded without a physical trespass, Brandeis said, we have to focus not on the means of the invasion, the trespass, but on the value itself. And that's why Brandeis insisted that warrantless searches of the home not only would be unconstitutional without a warrant, but they might even be unconstitutional with a warrant unless the crime to be revealed was extremely serious and the means of discovering it were unusually effective. So Brandeis insisted on a version of what Chris Slobogin in his important work, as you'll hear about, calls the proportionality requirement, asking courts to balance the intrusiveness of the search against the seriousness of the crime. But it's broadly an inspiring challenge to ensure that we focus not on formal means, but on the ultimate values at stake. Okay, fast forward to 1967, and the Supreme Court, in another case involving a suspected criminal and a telephone wiretap, seems to embrace Brandeis's notion, but in a way that inadvertently undermines his central conclusion. So the case is called Katz versus United States and involves a suspected gambler, and the technology then is a public phone booth. How many of you here remember public phone booths? I do, but some of, well, this is an older crowd, but some of our younger members, you probably never saw a phone booth before, but they used to exist. There were these boxes with glass on them, and they had doors that you could walk into and close. Superman, exactly. Do you know who Superman is? Sorry to pick on you. Right, people used to go into them and put on capes and come out and save buildings. Yes, you do need a revolving door. That would be much better. But the closed door was really important in the Katz case because this guy goes into the phone booth and closes the door behind him and basically runs his numbers racket or whatever it is. And here again, the government is eavesdropping on the conversation using a spike mic which can hear his conversation without physical trespass. And they indict and convict him. And like Olmstead, he says, you've got to exclude the conversation because my privacy was invaded. And the government, citing Chief Justice Taft's opinion, says, what are you talking about? There was no trespass. It was public property, and he didn't own it, and there was no invasion into his property rights. And in an important decision, the court repudiates the idea that private property sets the limits of the Fourth Amendment on the grounds that the Fourth Amendment protects people, not places. So that seemed to be a really good focus on the values. The Fourth Amendment, after all, protects the right of the peoples to be secure in our persons, houses, papers, and effects, regardless of what place we're in. But it did so in an inadvertently circular way. The central opinion in Katz was a concurring opinion written by Justice John Marshall Harlan II. And the test that Harlan embraced is that in order to decide whether or not an unconstitutional search has taken place, you have to ask, was there a subjective expectation of privacy that society is prepared to accept as reasonable? And here, said Harlan, yes, there was a subjective expectation because people expect when they go into phone booths in those days and close the door behind them that no one's going to be eavesdropping on them. The problem with this test was that it's very circular, because as technologies of intrusion and surveillance become more extreme, people's expectations are lowered with a corresponding diminution in constitutional protections. So if the president were to go on television tomorrow and say, citizens, in order to protect your privacy and ensure that your emails are not read by illicit government agents, I will fly drones in the air, which will track you from door to door and can reconstruct all of your movements and make sure that no government agent is spying on you. And if the president did that, then obviously all of us would have a lowered expectation of privacy because we would expect that drones were watching us. But according to this circular test, that would mean that our constitutional protections are lowered as well. So the problem with this Katz test is it seems to make our protections turn entirely on the nature of the technologies that are actually in the air and that we've come to expect. And in a bunch of other cases, recently, the Supreme Court has been struggling with the same problem. So just one more case to put on the table. It's called Jones versus United States. And it involves a global positioning system tracking device, such as the one that just clattered to the floor. I hope it's okay, but are you all right? Good, okay. So the GPS device is placed on the bottom of a car and tracks this suspected drug dealer, once again, war on booze to war on drugs, around for a month and reconstructs his movements. And the government concludes, based on this tracking, that he is indeed a drug dealer, because he's going to known drug houses, and indict and convict him. He objects that there was no valid warrant, as there wasn't. The government had gotten a warrant, but it was supposed to only be served in DC, and in fact, they tracked him to Maryland, and it was supposed to last for 10 days, and they tracked him for 11 days. So for the purposes of the case, there was no valid warrant, and the government took the very aggressive position, and this is the Obama administration, that you don't need a warrant to track someone's movements in public because we have no expectations of privacy in public. We all have to assume the risk that whenever we walk in public, we're being observed by our neighbors or by the police, who are allowed to track us for 100 miles, and therefore we need to assume the risk that we're being tracked by GPS devices. The Supreme Court unanimously rejected that claim, and it was clear that the government was going to lose the case when the first question was asked by Chief Justice Roberts, and he said, is it the position of the government that you could take tracking devices and follow the cars of the members of this court? And when the lawyers said yes, you knew the case was over. It's a truism in privacy cases that judges tend to vote against privacy violations when they can imagine their own privacy being violated, and this was a dramatic example of that. But the justices split in a really interesting way about why that search was unconstitutional. 5 justices, led by the late Justice Scalia, took the position that Taft had, essentially, in his Olmstead majority opinion, that whenever there's a physical trespass, then there's a search. And Scalia said because the government had to walk onto the guy's driveway to put on the GPS device and physically seize the car to affix the GPS device to it, there was a physical trespass, and therefore a search had presumptively taken place. 4 justices, led by Justice Samuel Alito, a surprising combination to some, objected, it makes no sense to focus on physical trespass. After all, said Alito, all of our cell phones are walking GPS tracking devices, and the government could have constructed the guy's movement merely by subpoenaing the geolocational records from his cell phone, which are stored in the digital cloud, that is distributed third-party servers owned by Google or Yahoo or whoever your phone company is. And Alito said, rather than focusing on the physical trespass, we have to focus on the value, essentially the amount of information that can be revealed by an intrusive search. And Alito said we do have an expectation of privacy that the whole of our movements for a month won't be spied on, because 24/7 surveillance can reveal so much about us. Our thoughts, our unexpressed sensations, our emotions, the political rallies we attend, the friends we associate with. Therefore, said Alito, you need a warrant for month-long surveillance. Scalia fired back, this is a totally mushy test. You can track people for a day, but not for a month. What's your test, Justice Alito? And Alito said, well, a month is too long and a day is okay, and if you're unsure, get a warrant. And then Scalia said, we have to ask what the framers thought. And Alito said, we can't ask what the framers thought. There was no cell phone tracking in the day of the framing. And Scalia said, no, but there's an analogy. You could imagine a tiny constable hidden under a carriage and eavesdropping on the conversations of the carriage as they were taking place. And Alito responded, well, since you'd need 1,000 constables to get the coverage of a single GPS device, they'd have to be very small constables or a very large carriage. So it was a wonderful example of both the limits and possibilities of originalism, the philosophy that the Constitution should be interpreted in light of its original understanding, and it left a dividing line on the court between the justices who wanted property rights to be the measure of the privacy rights and those who didn't. There was a really important concurring opinion by Justice Sonia Sotomayor, and that I'm going to use to set up our discussion, because Justice Sotomayor raised a question that we asked our scholars to answer. Justice Sotomayor said, we really need to rethink our entire approach to digital privacy, because right now it's circular to focus on subjective expectations of privacy, and it's also the case that we need to rethink a particular doctrine which the court has embraced, which holds that when I surrender information to a third party, I lose all expectation of privacy in that information. This is called the third party doctrine, and it sounds technical and wonky, but it's really important for you to think about, because this says that when I voluntarily surrender information to a bank, I've lost all expectation of privacy in it, and the bank can turn it over to the government without a warrant. That proposition, which the court offered in the 1970s, was so outrageous to citizens that Congress repudiated it in the Bank Protection Act and said, no, you do have some expectation of privacy in your bank record. But because Congress has not passed a Geolocation Privacy Act, although such an act is pending before Congress with bipartisan support, at the moment, without statutory restriction, the government could argue that because when I walk down the street, I voluntarily emit geolocational information that is then stored in distributed third-party servers, I voluntarily surrendered that information and therefore have no expectation of privacy in it. And Justice Sotomayor said, in an age when all of our movements and locations and records and papers are stored in the digital cloud, it makes no sense to say that merely because I happen to store my documents on Microsoft servers or on Google Docs or on AT&T servers that I've abandoned all expectations of privacy in them. And Justice Sotomayor was correct that this is a problem. I think justices on both sides of the aisle might agree that without an alternative to the third-party doctrine, then we have less privacy in the 21st century age of digital searches than the framers took for granted. But no justice has come up with an alternative to the third-party doctrine, which is why we commissioned the greatest thinkers in the country to do precisely that. And you're about to meet them, and I'm so looking forward to their presentations, because we really have to solve this problem, ladies and gentlemen. And it's a wonderful thing that this diverse group of scholars has set their formidable intelligence to addressing this crucial issue facing America. So it is now my great pleasure to introduce our Senior Fellow for Constitutional Studies and impresario for this superb project, Tom Donnelly, and our panelists. And Tom will introduce the panelists, and take it away, Tom. Thanks so much.
Thanks, Jeff. Oh yeah, you can come now too. Well, thank you everyone for coming, and thanks, Jeff, for that terrific keynote. Needless to say, Jeff is a very tough act to follow, but we shall try our best. And I couldn't be more thrilled to bring together really three of the leading experts on issues of cybersecurity and digital privacy. And I will say, for those of you who you listen to this presentation and are really excited about the issues, please do check out all of the white papers. We have the website up there, constitutioncenter.org/digital-privacy. So go online, check it out. You could read the papers by our three scholars here and two others, and a great introduction by Jeff. So please do that. But right now, I'm just thrilled to introduce you, say a little bit about each of our panelists and why we're so excited to have them here, and then just dig right into the conversation. So in the middle, we have Jennifer Daskal, who's an associate professor of law at American University Washington College of Law. She teaches and writes in the fields of criminal, national security, and constitutional law. And between 2009 and 2011, she was counsel to the Assistant Attorney General for National Security at the Department of Justice. We have Jim Harper on the end here, and he's the vice president of the Competitive Enterprise Institute. Previously, he was senior fellow at the Cato Institute. He also served as counsel to committees in both the U.S. House and Senate, and he's gone on to represent companies such as PayPal Digital Globe, VeriSign, and he served as the Global Policy Counsel for the Bitcoin Foundation. And then finally, next to me here, we have Christopher Slobogin, who's the Milton R. Underwood Chair in Law, Director of the Criminal Justice Program, and Affiliate Professor of Psychiatry at Vanderbilt University. He's authored more than 100 articles, books, and chapters on topics relating to criminal law and procedure, mental health law, and evidence. He's also currently an associate reporter for the American Law Institute's Principles of Policing Investigation Project. So please give a warm National Constitution Center welcome to Chris Slobogin, Jen Daskal, and Jim Harper. So now, given the topic of Jeff's keynote, I'd love to start with you, Jim, because part of your paper, one of the main calls of your paper is to recognize one of Justice Brandeis's forgotten colleagues, Justice Pierce Butler. And you may get a sense, given Jeff's enthusiasm and the audience, that you are in the den of Brandeisians here. So tread carefully. But I'd love to hear, tell us a little bit about Justice Butler and Pierce Butler and why he may offer us a way out of the problems of the Fourth Amendment in the digital age.
Well, thank you so much for having me here. I'm delighted to join my co-panelists, and this is a great institution and a great room. You've gotten a great introduction to the issues from Jeff Rosen. I'm delighted that Olmstead's phone is here. I'll issue a challenge to Jeffrey Rosen, though. I'd like to see Smith's Monte Carlo. In the case of Smith versus Maryland, which applied the third-party doctrine to our telephone communications. It's what the NSA relies on for legal authority to collect telephone information. Smith was the driver of a Monte Carlo, and I'd like that car to be collected for this institution. Interestingly, today, just driving a Monte Carlo provides probable cause for arrest. But I'm a non-Brandeisian when it comes to Olmstead. Pierce Butler doesn't have anything near the popularity. Didn't write in a way that would last. He was a technical person. He was a relative conservative, though a Democrat. He was a conservative jurist. Didn't write with flair and style. Tried to mechanically apply the law to the facts and not do the Brandeis brief type stuff that's so famous and that law students are taught is so good. He talked about these communications in a sort of dry legal sense. What's going on when you use a telephone? When you used a telephone at that time, you'd effectively rented a copper loop from the telephone company. That copper loop was yours. And he characterized the rest of the transaction so that the communications belonged to the parties. And I think that's a tremendous and important innovation in thinking at that early stage. And for me, it created continuity that should be applied today from physical mail, which was protected by statute and later through constitutional Fourth Amendment affirmance, as something that's sacrosanct. When a sealed envelope travels from your home to somewhere else, the interior of that envelope is as if it's in your home. It is fully protected by the Fourth Amendment, and in part because you have sealed it inside opaque material. A telephone conversation is very similar at a high level of abstraction to writing something in a letter. You're abstracting it. In this format, it's an analog signal, an analog electrical signal, and it passes invisibly and inaudibly along a wire to be reconstructed at the other end. As Pierce Butler said, it belongs to the parties. It's the property of the parties. It's something of theirs. And so treat it as papers, treat it as effects, that brings it within the Fourth Amendment. Then the question is whether the government is reasonable in accessing it, rather than what came from Katz, which is whether people are reasonable in wanting privacy. So, phooey on Brandeis. I like Pierce Butler.
Thank you for that, Jim. Turning to you, Jen, you in your paper tackle the difficult issue of cross-data border disputes. And I think for a non-legal audience that may seem a bit abstract, maybe a little intimidating. Just to make it concrete for us, can you give us some concrete examples of why that issue really matters in the real world?
Sure. So I first got interested in this issue when I learned about a case that was ultimately decided last summer by the Second Circuit, but it dates back to 2013. And the government served a warrant on Microsoft for data. So we've heard a lot about the third-party doctrine. It's pretty well established that at least when the government's getting the content of your emails, the content of your communications, they're required to get a warrant. Sixth Circuit court said that, and the government and all major providers are operating as if that is the law, even though the Supreme Court has not yet weighed in. So in this case, Microsoft got a warrant, and they were seeking emails and other data from Microsoft. And Microsoft said, we'll turn over some of this data, but actually those emails you want are stored in a server in Ireland. And the warrant authority, this is not a constitutional issue, but this is not a constitutional issue in terms of a Fourth Amendment issue, but the warrant, it's a statutory issue. The warrant authority only applies to the territorial boundaries of the United States. So it can't reach that data that's outside the United States. The government said, wait, that's crazy. You, Microsoft, are based in Reading, Washington. You can access this data from Reading. We're not asking you to go over into Ireland. We're not sending any agents into Ireland. We're asking you to just retrieve the data that you guys move around all the time for all kinds of business reasons and turn it over to us. This is a territorial exercise of the warrants authority. Both lower court, the magistrate judge and the district court agreed with the government. The Second Circuit reversed last summer. And it's causing all kinds of problems, I think, for security reasons, for privacy reasons, and also for economic reasons. But for security reasons, so Microsoft operates itself in a fairly location-driven approach to the way it stores its data. So Microsoft's response was here, go to Ireland, use the diplomatic processes, what's known as a mutual legal assistance process, and make a request to the Irish government, and the Irish government will access that data and turn it over to us. Even in that situation, it's not very satisfying from a security perspective if you're talking about kind of a fast-moving investigation. It takes the Irish government an average of 15 to 18 months to respond. That's not atypical. We, the US government, take an average of 10 months to respond to mutual legal assistance requests when they come the other way. Big problem. Other companies, like Google, for example, organizes itself so that it's constantly shifting around the data. They don't have a stable location approach to the way they manage and store data. It's often the case that an email will be stored in one jurisdiction and an attachment in the other. So what's happening with respect to Google, at first, after this case came down and all the providers were operating as if it had nationwide effect, even though it's just technically limited to the Second Circuit, Google says, we don't know where our data is, so we're not turning over any of it. They then, eventually, their engineers designed a system, which they said they didn't have before, where they could tell whether the data is in the United States or outside the United States. So now they'll turn over data that's inside the United States, but they still assert that they can't identify where outside the United States the other data is. So the US government has no idea where to go to serve the mutual legal assistance request. So you can see why this is a problem and why people are concerned about this. On the privacy side, now interestingly, when this case came out, there were lots and lots of amicus that were filed on behalf of Microsoft's behalf. It was described in the press as a major privacy win. It was kind of sold that way. I think that's a huge mistake, because if you think about it, in this case, the US government obtained a warrant based on probable cause. That's the gold standard. That's what we want to apply if we reformulate the third-party doctrine to require that kind of gold standard. Instead, what this would require is that the US go to foreign countries and ask them to access the data according to their own standards. And as much as the rest of the world really likes to beat up on the United States for being so surveillance friendly, the reality is that our standard of a warrant based on probable cause reviewed by an independent judge is a higher standard that applies in most other places. So it's really ultimately potentially a privacy loss for individuals who then potentially have their data accessed via other means. And then and I'll stop in a second, but just on a normative sense, it makes no sense for jurisdiction over data to turn on the question of where data happens to be located at any given moment. There is often no connection between the things that we think we ought to care about, like where did the crime take place? Where's the target? Where's the victim? What are their nationality? All the things that you would think would matter for principles of democratic accountability and for other reasons are not in any way necessarily tied to the data. The location of data, at least to the extent that it's data that's controlled by third-party providers, depends on the business decisions of companies like Google, Microsoft, Facebook, that are making these decisions for reasons of efficiency, for reasons of tax purposes, for reasons of energy costs. And so one of the goals in the paper that I wrote about is how you start thinking about a system that matches the normative interests at stake with the jurisdictional hooks that apply, because those jurisdictional hooks really matter for a range of security and privacy reasons.
Thanks so much for that, Janet. I look forward to drilling down both into what Jim and Jen have said. But let's place Kris's paper on the table right now. And so, I mean, would you call for, in this context, in terms of balancing privacy and security, is, I would say, a nuanced approach, and one where you really call for the use of a proportionality principle? And I mean, maybe just to use the example, maybe just walk through your approach, maybe even using an example that you had in your paper, just how that might work, maybe in a suspect-driven cloud search context.
Okay, well, first of all, I'm very glad to be here. Terrific institution. I want to thank you all for inviting me. I have tried to deal with the coming end to the third-party doctrine. I think the third-party doctrine is on its last legs. If even Justice Alito is questioning whether the third-party doctrine makes any sense, I think we are on the verge of seeing it end. But what does that mean? What does it mean if the third-party doctrine no longer exists? It means that the Fourth Amendment is going to apply to a number of different kinds of government actions that up to this point were not governed by the Fourth Amendment. For instance, accessing data from third parties like banks, phone companies, following people in their cars through GPS locational devices. So what would happen in that kind of regime? How would the Fourth Amendment apply? And I don't have the perfect solution, but I am working toward one. And it does depend upon this proportionality idea that Jeff Rosen referred to and that you just alluded to. The idea is this, that right now the debate is basically between the absolutists and the people who want to stick with the third-party doctrine. The people who adhere to the third-party doctrine do not think that a warrant or any other kind of justification ought to be required in order for the government to get a hold of our bank records, our phone records, any other information surrendered to a third party. I just want to make clear what the law now says, because it may not have been totally clear from what Jeff was saying. Though Jeff was very clear, generally speaking, I just want to make absolutely clear what's going on with the third-party doctrine. If the prosecution, if the government wants information from your bank about your bank transactions over a day, over a month, over a year, they do not need to abide by any requirement under the Fourth Amendment in order to get it. They don't need a warrant. They don't need probable cause. They don't even need the lesser suspicion that's called reasonable suspicion, the lesser justification that's called reasonable suspicion. That's the implication of the third-party doctrine. If they want to find out who you've called over the last day, over the last month, over the last year, because you supposedly have surrendered the information about your phone calls to the phone company, the government needs absolutely no justification in order to get it as far as the Fourth Amendment is concerned. Okay, that is the implication of third-party doctrine. And of course, prosecutors love the doctrine because at most all they need is a subpoena. And in many situations, they don't even need a subpoena, which is much easier to get than a warrant. A warrant, as you probably know, requires probable cause. A subpoena is very easy to get. It basically only requires a showing of relevance, which means virtually nothing in terms of what the prosecution has to show. So prosecutors, government officials, many other people like the third-party doctrine. On the other side of the spectrum, you have people who think a warrant should be required for everything. If in fact the third-party doctrine is eradicated, and we call all of this a search when government goes after the phone company records or bank records, they argue that a warrant based on probable cause should be required. I think that's going too far in the other direction. I think, first of all, if, for instance, the police are only trying to obtain information about one phone call that I made to another individual, one bank transaction I made, I don't think the privacy intrusion is anywhere near as great as, for instance, what happened in the Jones case, where they followed that individual for 28 days. It's nowhere near as great as if they get a month's worth or 2 months' worth of bank records or credit card transactions and so on. So I think as a normative matter, it doesn't make sense to require a warrant every time a third party is approached for information about our information. And I also think as a practical matter, it doesn't make much sense because many times police are trying to get that day's worth of information or that 1 hour's worth of information in order to develop probable cause, right? It takes some information in order to go in front of a magistrate and convince the magistrate there is probable cause. If we require probable cause right from the get-go, law enforcement would come to a screeching halt. They just wouldn't be able to develop probable cause. So that's why I come up with the proportionality principle. The idea being that the justification the government needs in order to get information should depend upon the type of information be obtained by the government. For instance, a medical record is much more private than information about one phone call, as well as the amount of information, a month's worth of phone calls as opposed to a day's worth of phone calls. Now, the huge problem with that approach is that it's, and this was Scalia's response to Alito that Jeff described, exactly how do we implement this proportionality idea? Are we very formalistic and say, oh, if you get more than 2 days worth of data, you need probable cause, less than 2 days, you don't? And I have to admit, that's a part I'm still working on, though in my paper, actually, I won't go into detail now unless you want me to. In my paper, I do try to draw some lines with respect to, for instance, when the police have a suspect. They have someone they think may have committed a crime. And essentially what I say is, it depends on the type of record and the amount of information being obtained. The more the government's trying to obtain, the more justifications needed. And I essentially suggest some rule along the lines of a 48-hour dividing point. For various reasons having to do with existing case law. 48 hours tends to be a dividing point in a number of Fourth Amendment cases. I also try to develop some other nuances in the paper that I won't go into right now, because there are many, many different kinds of data-driven searches that the government engages in, not just searches when they have a suspect, but also searches based on profiles, also searches based on event when they have no suspect, but they have a crime they want to solve and they want to find who was near the scene of the crime at the time. And there are at least 2 other situations where data is also sought by the government. But I'll end with that.
We'll definitely touch on some of them in a second. But returning to you, Jim, you've heard a bit about Kris's approach. You know, I'd love to hear applying, you know, Justice Butler's approach, or, you know, you really call for an approach that's tethered closely to the Fourth Amendment's text. And so I'd love to hear, you know, for you, what if a judge is applying your rules, what counts as a seizure, search, how did digital information end up within the Fourth Amendment, and just sort of walk us through maybe a hypothetical analysis.
Well, I probably am on the absolutist side of things, which might be a little extreme. Getting there from here, in terms of societal expectations and how law enforcement do their job, would be pretty hard with what I propose. And so being reasonable is very reasonable. I appreciate that. But proportionality, as you've identified, is hard for judges to administer. Just like the reasonable expectation of privacy test, it asks a panel of judges, 9 in the case of the Supreme Court, 3 in the case of most federal circuit courts, and 1 in your district court or trial court, to figure out what society's privacy preferences are and whether those are reasonable. That's not a juridical exercise. The judges are used to figuring out, okay, this set of facts, does it constitute this thing happening in the law? What about this set of facts? Did that other thing happen? Was there a contract? Did the person hit the other person? Then we know whether there's something that's within this legal rule or that legal rule. Proportionality has that same problem as reasonableness, is that judges aren't well positioned to figure out what the proportions are. And you could take even, as I know Professor Slobogin has thought through, you know, 48 hours of one set of data might be about right, but 48 hours of a different set of data, say going to your political protest or your doctor or whatever the case may be very, very revealing. So that's hard to do. What I've tried to do is come up with a rule that judges can apply. And literally going back to law school type stuff, what are the basic terms of the Fourth Amendment? Well, the Fourth Amendment asks, was there a seizure? Was there a search? Was it of protected things, that is persons, houses, papers, and effects? And if all those things are satisfied, then you'd go and look into whether or not it's reasonable. It takes a lot to get through that, and I actually reverse the order that the Fourth Amendment uses, because very often seizures are what precipitate a search. So in the paper, I argue, for example, even a minor seizure can be very important. And in the Jones case, it was an arguable seizure of a car to use it to move a GPS device around. But one of the cases I refer to is Class versus New York, where law enforcement, thinking that Class was driving a stolen car, opened the car door to look at the plate that has the VIN number, and it wasn't there, so they moved some papers that were on the dashboard. Seizing the car by opening the door in a very, very small way, and by moving those papers, getting access then to the information that allowed them to move forward with their prosecution. Well, In my view, you recognize that as a seizure. The following steps in the analysis happen. Same with search. Search is a little bit difficult as well, but we kind of know what searching is like. It's doing things that have a purpose of finding other things. Very often, searches are signaled by seizures. That is, I picked up the piece of paper. I moved an item from point A to point B. I took hold of the suspect. These all signal that a search is about to come. But then that purpose of finding. There's a case called U.S. versus Serrallo, where law enforcement took a private plane and flew it over the property of someone they suspected of having growing marijuana or something. I forget the facts in detail. The court found that wasn't any kind of Fourth Amendment violation. But I think very much that if you go looking for that purpose of finding something, it's obvious that they were searching for the marijuana plants that they suspected were in there. So apply apply the law to the facts as you would any statute. Was there a seizure? Was there a search? Was it a person's houses, papers, and effects? There are details there as well. And then you ask the real question of the Fourth Amendment, which, as I said earlier, was government action reasonable? Not were our feelings about privacy reasonable. I think it's a more juridical way of administering the Fourth Amendment.
Well, thanks for that, Jim. I'll return to you just in 1 second, Jen. I just want to let Kris hop in because I know that Jim talked about your proportionality principle. Maybe just respond to that.
Yeah, so I actually like Jim's approach to the definition of search. I'm totally in favor of defining search very broadly as looking for something, examining something, trying to find out something. In fact, Justice Scalia, in his original approach, ended up at a position very similar to what Jim just described. As Jeff mentioned, Scalia tended to take an originalist approach to the Constitution, and in one of his opinions having to do with the use of thermal imaging devices to detect heat differentials inside a home, he actually dropped a footnote to his favorite source, Webster's Dictionary, published in 20, and said, look, this is the definition of search. This is probably the definition we should adopt for Fourth Amendment purposes. Now, Katz had already been decided. He wasn't going to reverse Katz. But he took a position very similar to the position that Jim just described. What I may disagree with Jim on is what happens after you declare something to be a search. That is, what kind of justification does the government need in order to carry out a search? And what the Fourth Amendment says is searches have to be reasonable. It doesn't say if you have a search, you have to have probable cause and a warrant. It says searches have to be reasonable. And I think the word reasonable almost inevitably suggests it's some kind of proportionality approach. And in fact, it's an approach that the court has adopted in Fourth Amendment situations. For instance, whereas an arrest and a full search require probable cause, a stop, which you've probably heard of, you've heard of stop and frisk, a stop does not require probable cause. It only requires reasonable suspicion. Why? It's not as intrusive as an arrest. It's a brief stop. It's not a full-blown arrest. A frisk, which you've probably heard of, it's a pat-down of an individual, only requires reasonable suspicion, which is a lower level of justification. Why? It's not as intrusive as a full search. The Supreme Court's already adopted this idea. It's not brand new with me. I'm trying to apply it, however, to the data situation. And then the final point, with respect to whether judges can do this or not, I admit it's not particularly easy for judges to do, but as you've just heard, Jim's own approach also is difficult judicially, and I'm not necessarily arguing that everything should be done by judges. I think legislature should have a very significant role in figuring out just how proportionality should be applied in this situation. Congress has already done this in a number of situations, including electronic communications, and I think it could certainly do it with other kinds of data-driven searches as well.
Excellent. So Jen, I'd love for you to weigh in on this question about alternatives to third-party doctrine, and then we could return to some issues of cross-border data.
Sure. No, I just wanted to say that as I'm listening to both of you, it actually seems like your approaches are quite compatible in a lot of ways. That what you're talking about is, both of you are talking about what do we define as a search. You're focused more on rethinking the third-party doctrine. You're focused more on looking at traditional property rights. But at the end of the day, you still get to the question, which I think is what Kris just said, is what is reasonable? And is this reasonable? And that in and of itself kind of conjures up some sort of balancing test. And I think that's what judges have done, will continue to do, have to do. I think it's ideal if Congress steps in and answers those questions in a much more nuanced way that they're not doing right now. I think to the extent that we can get Congress engaged on questions of when are searches of location data requiring a Fourth Amendment, requiring a warrant based on probable cause, a whole host of bank records cases. All those questions, I think, are much better suited for the political branches than the courts. But at the end of the day, the question for the courts is, was this reasonable or was this unreasonable? And that in and of itself imagines some sort of balancing test.
And so, Jen, you were originally today scheduled to testify before the Senate Subcommittee on Crime and Terrorism. I'm curious, how sanguine are you at the possibility of legislative action, whether on the cross-border data issue or on digital privacy generally? Is this an area where we might see some unity across party lines?
So I think it depends on the issue. So probably many of you know that there's been a bill that's been languishing in Congress for a very long time called the Email Privacy Act that basically would do what I said the Sixth Circuit already has require that there's a warrant before the government can access the content of your emails or other communications. It's passed the House 419-0. It passed by a voice vote in February, and it's been stalling in the Senate for a variety of different reasons. I think most people who look at this think that this is a good idea and it should pass. It's difficult to move things through Congress. On the cross-border data issue, which also relates to the same statute, the Electronic Communications Privacy Act, I'm actually cautiously optimistic that we will see some legislative movement here. The results of the case that I talked about earlier that tells U.S. law enforcement you can't access data overseas directly from U.S.-based companies with a warrant is, as I said earlier, causing lots of problems for the Department of Justice. So you have the executive branch really seized on wanting to fix this problem, and I think you're starting to see some bipartisan coalitions within at least the Senate of senators who are really focused on this and wanting to solve this problem, both for the ability of the United States to be able to access data and also the converse problem, which I haven't really talked about much, but resolving a provision in that same bill that precludes US-based providers from turning over data to foreign governments so that you have the converse problem on the side of foreign governments to UK officials investigating a London murder involving a British target. If those communications were using a UK-based provider, the British government would be able to access that data within days, if not sooner. It turns out more and more British citizens, British residents are using US-based providers, and so the British government is finding that they can't access that data directly from the provider. They have to go through this laborious mutual legal assistance process. They have to wait many months. They're really frustrated. It's one of their highest diplomatic priorities with respect to the United States is to try to get this particular provision amended so that they can, in certain limited circumstances, access data directly from US-based providers when they're accessing the data about somebody who's not located in the United States, not a US citizen, not a legal permanent resident. And again, I think that's the kind of approach that makes sense because it ties jurisdiction to the location of the crime, the government interest in the crime, as well as the location and the nationality of the target, as opposed to the location and the nationality of either the service provider or the data that that service provider controls.
That's great. Now, Jim, returning to, Jen sort of framed this as there are many points of agreement between you and Kris. I am curious about probing more about this question of reasonableness, and if the key thrust of your paper is to try to create an administrable Fourth Amendment. What sort of indicia might judges look to in a rigorous way to figure out whether or not a government action is indeed reasonable?
Yeah, alas, there still has to be some judging in cases. I tried to squeeze all the last judging out of it, but didn't succeed. In the law, people are familiar with the idea of the reasonable man or reasonable person standard. Reasonable man is the archaic version. And you apply it in lots of different circumstances. And in particular, the difference between reasonableness of privacy expectations and reasonableness of government's behavior is that in the latter, you have a particular fact situation. And the judge can look at the situation and say, how much did you know about this situation? How intrusive was this literal situation? Rather than, on the other hand, saying, how intrusive is cell site location information overall? Right? It just has, there's so many countless ways that information like that might be used. So it tries to narrow the judging down to discrete and particular fact patterns. Let me say a point that came to my mind, and I'm not expert in your area, so I might get some thinking wrong, but I'm very interested in how sometimes, and you haven't made this argument, but I've been very interested in how both domestically and particularly in the international arena, the argument is that it's very hard to get a warrant, so we need a lower standard. And I'd very much like to see, I've argued for this and gotten a couple of javelins from people who are even crazier libertarians than I am. I've argued, hey, warrants should be easy to apply for and get. You should have an online process, and there are some security challenges to doing this, but a process where you can get that warrant within minutes or tens of minutes or under an hour. And internationally, the same kinds of things, at least with countries that have fully established legal systems and access to electricity full time, why can't you turn that around in 2 days or 3 days or 4 days or something like that? And so I caution again, and Professor Daskal didn't make this point, I caution against that argument that it's really hard to do, so let's lower the legal standard. The governments in all these cases should work harder on making warrants more available, because we do want effective crime control when it's justified by probable cause.
Right. So I think there's two issues that are going on here, at least with respect to international cooperation in this area. First, the way the mutual legal assistance process works, rather than a foreign government being able to directly access the data from a service provider, they go to the other foreign government. They then have to look at it. They then send it to a local prosecutor or whoever. In the US, this is how it works. So we send it to a local prosecutor, generally. Local prosecutor then has a big workload. Responding to the foreign government request isn't necessarily at the top of the workload. They have to go to a judge. It goes back to the local prosecutor. It goes back to the Department of Justice, and it goes back to the government. Even when everything's in place, that's kind of a slow process. But I think there's a bigger issue here, which is that we have a standard of a warrant based on probable cause with review by an independent judge. The concept of probable cause is an American concept. It is not a turn of phrase that's used in any other country. And so I think countries are legitimately frustrated about this idea that they have to apply an American standard, American procedures, American rules when they're accessing data about their own investigations with respect to local crime, local targets, local nationals. Now that said, I absolutely think that one of the United States' obligations and really opportunities here is to set a minimal set of baseline standards that have to apply to these types of requests. So not every government in the world should be able to say, I want data about my citizens, I'm going to go to this provider, and you have to turn it over. The approach that's being pursued right now would permit certain countries to be eligible to enter into executive agreements where they could access that data, but pursuant to very specific procedural and baseline, substantive and procedural standards, things like there has to be a credible and articulable predicate, factual predicate for the investigation. The access has to be targeted to a particular person, place, device, account. The kinds of things that we would want judges to do when they're approving warrants, but just stated in language that matches how they operate in their systems, and ensuring that there's harmonization and collaboration across borders in legitimate investigations.
Very quickly, Jim, and then we'll turn back to Kris.
Yeah, just a real quick question. What about mutuality of the crime? That is, if someone in France is pursuing a speech crime, should a U.S. provider respond to that would violate the First Amendment in the U.S.?
So the legislation that's pending says that it has to be a serious crime, and it has to satisfy free speech principles. So another piece of this is the United States First Amendment is a very different beast than international human rights free speech standards. And so the agreement specifies that if there's a concern on for speech reasons, then the provider cannot turn it over directly.
Excellent. So, Kris, I'd love for you to respond to anything that strikes you about what...
Anything?
No,
Yeah.
about what Jen and Jim have said. But, more specifically, I think we're really wrestling with this question of how do we administer some sort of reasonableness inquiry? You had suggested earlier maybe looking to, court decisions, and maybe, what approaches there seem to be prevalent and make sense. In your paper, you also point to even I don't want to suggest that this may be administrable, but that we do have public opinion data even on people's views about privacy. What are some of the indicia that judges should be looking to in this context?
Okay, so the public opinion data that you just referred to, I did do some research which asked people how intrusive they thought various kinds of government searches are. Because after all, the Katz test that Jeff referred to, that Harlan formulated in his concurring opinion, was expectations of privacy that society is prepared to recognize as reasonable. That to me suggests we need to find out what society thinks about privacy, and I think that kind of research shouldn't be dispositive, but it should inform judges' decisions about what a search is when the police, the government is engaged in something that is so intrusive that it should be considered a search. I also think it should help inform how we apply the proportionality principle. If society believes that a particular kind of government action is extremely intrusive, then we ought to require a very high level of justification. Probable cause, or perhaps even something more. Jeff mentioned, for instance, Brandeis's prescient statement about how the government might be able to read minds at some point. I think if the government ever does develop that ability, and neuroscientists are getting close, then we ought to require way above probable cause in order to get information. In fact, I might say you can't get that information. That would be an area that would be off limits to the government. But that would be the proportionality principle in operation again. You have to figure out exactly how intrusive a government action is and then determine the justification necessary to carry out that government action. Now, I have no problem with what Jim suggested in terms of expediting the warrant process. Police today have access to telephonic warrants. They don't have to go to the station house and peck out on a typewriter a warrant application. They can call up a judge and say, Judge, this is what I've got, maybe patch in the prosecutor and have the prosecutor involved in the conversation as well. That I have no problem with. What I do have a problem with is diluting what probable cause is in a situation involving intrusion that requires that level of justification. If the police are going to search a home, if they're going to go through a month's worth of bank records, I think they should really have to have probable cause, not some diluted notion of cause down at the reasonable suspicion level or down at the relevance level. So I would be against that particular approach to reasonableness. The other part of my paper that is relevant to all of this suggests that we need to think about different kinds of searches that government engages in. We've been focusing mostly on suspect-driven searches. That is, when the government thinks they maybe have a bad guy and they want to get as much information as possible about that person. The proportionality principle would apply there. The more information they want to get, the more justification they need. But there are other kinds of data-driven searches as well. There are other kinds of searches where the government's trying to get information from a third party. Sometimes police use profiles. This is a relatively new development. But we saw it first come to light after 9/11. At least it was first reported widely after 9/11. Some of you may have heard the Total Information Awareness Program developed by Admiral Poindexter. Does that ring a bell? What I love about this program is how totally tone deaf the Department of Defense was in terms of PR. Because the icon they came up with for total information awareness was an all-seeing eye perched upon a pyramid looking out at the globe, accompanied by the logo, "Knowledge is power." Scary as hell. But that's what they came up with in order to symbolize total information awareness. The idea was to collect any and all information about everybody and put it in big government computers. And then, once the information was in the computers, use algorithms or profiles that supposedly could identify who was a terrorist and who wasn't to figure out who was a terrorist. Well, of course, it was a total failure in two different respects. One is they couldn't develop a profile that came anywhere near identifying who was a terrorist. But even more importantly, in some sense, it failed in the sense that the huge amount of government collection of information associated with TIA was so offensive that even the conservatives in Congress, even the conservative Democrats and the Republicans, defunded TIA by voice vote. They were so upset, I think primarily by the icon, actually, truth be told, more than anything else, they defunded it by voice vote in 2003. That doesn't mean that programs like TIA don't exist. In fact, Edward Snowden has made it clear that we still have programs like TIA. But these kinds of programs have been limited to some extent. The profile search comes into play when the information has been collected, and then the government tries to apply a profile to it. I'm not going to go into detail, unless we have time later, as to how one might regulate profile searches, but I think they're a very dangerous development that needs to be closely examined and very closely regulated, because otherwise we could have very wide-ranging searches that are not subject to any kind of judicial or legislative regulation.
Thanks for that, Kris. And now we have some great questions from the audience, so we'll turn to some of them, and I'll sort of throw them all out to the panels and respond accordingly. Here's the first one. Why not require a warrant if the information or evidence sought is necessary to prove an element of the crime, regardless of where or how it is obtained?
I can answer that, I guess.
Sure, hop in, Kris.
Yeah, I think that certainly would be the absolute position, that any time any information sought by the government, a warrant is required. Let's say cops want to find out if Tom Donnelly has called a drug dealer. Do they have probable cause to get a warrant to get his phone number? No, they don't. Now, so one response to that fact situation would be, okay, well, then you can't find anything about Tom's calls. That would be fine in some people's eyes. In many people's eyes, though, that would not be a good call if they have some kind of suspicion with respect to Tom. Perhaps an anonymous phone call that Tom has been collaborating with a drug dealer, perhaps some kind of eyewitness account, not amounting to probable cause. Then they should be able to get information about who Tom has called to verify the innuendo of the information they already have. If probable cause were required every single time the government wanted to get information, it would be very difficult for the police ever to get an investigation off the ground. So that would be one response. And then the other response, which I've already described, is I think, in fact, that if the police only seek one little tidbit of information, they just don't, as a normative matter, need as much justification. It's not as privacy intrusive, and therefore they don't need as much justification. My empirical research that you referred to earlier bears that out. When you ask people about different scenarios, they're more bothered about obtaining medical records as opposed to utility records, obtaining months' worth of information as opposed to days' worth of information.
I like the spirit that animates that proposed rule, but I think there are probably real administrative challenges to it, because I don't mean legal challenges. I mean you'd have a hard time administering such a rule, because often in investigations you don't know what's actually going to be charged. You don't know what's actually going to happen. You might have suspicion or probable cause for one crime, and you end up trying to prove another one, and you don't know what the details of the crime are that you're going to charge. So you don't know. You have the process backward there if you have a warrant requirement for proving elements of a particular crime when you don't know what the charged crime is going to be later.
Excellent. This one's, I think, best for you, Jen. If the government can't access data stored outside the U.S., wouldn't that be an incentive for providers to store all data outside of the U.S.?
Possibly. So I don't think providers are really in the business of wanting to necessarily hide all activity from the government. In fact, many people think that providers have been way too cozy with the government. So I think it depends on your view of providers. I don't think that most of the major American tech companies are actively trying to move data outside the United States in order to evade legal process. There's no indication that's happening. But it does provide a blueprint for somebody who was a more malicious actor who did want to do that. And I think just for a whole host of reasons that I've already said before, that it makes very little sense for a government's ability to access data to turn on the decisions of third-party providers of where that data is. And one other piece about that is that for principles of democratic accountability, we're talking about what is reasonable and maybe the courts decide, but it's much better for the political branches to be making those decisions. And the political branch is engaged because the citizenry engages. If we don't know where our data is and thus who has access to data, we have no ability to even know which political entity to go to try to shape the rules. So there should be clarity for all of us, at least, in terms of which government is most likely to have jurisdiction over our data and therefore have some say in the rules that apply with respect to that government. If the rule is based on location of data, at least under the current system, unless something dramatically changes where we are notified every time our data moves around, which I think would really grind some of the efficiency of the internet to a halt, we really aren't in a position to have that kind of knowledge that allows us to engage the democratic processes in ways that I think are important.
Excellent. This is for any of you. What about preventing ISPs, Gmail, et cetera, from accessing or examining the content of our emails, web browsing, et cetera? Despite the recent law passed by Congress, do you think there is case law that supports protecting our privacy in these situations?
There's not only case law, there's a federal statute that requires a warrant before the government can get content of information. Is that the gist of the question? Am I understanding it correctly?
Well, it's that, but even more broadly, whether or not we should be limiting private companies' ability to take...
Oh, I see, private as opposed to government. I'm sorry. Well, the Electronic Communications Privacy Act actually does also put serious limitations on the extent to which private companies can access information and even surrender information they might have in their possession to the government. Let's say a private company finds out about some criminal situation as a result of communications in their possession. The Electronic Communications Privacy Act, interestingly enough, prohibits the private company from revealing that to the government unless it's necessary to prevent some kind of violent, dangerous situation from occurring. But there are probably other answers to that question.
If I understood the question correctly, I think it was focused on the regulation of the private companies. And I think that's an area where the United States really falls short. So as I said before, the United States standard of a warrant based on probable cause reviewed by an independent judge really is kind of the gold standard. It's a very high standard that at least provides significant protections relative to what governments are required to do to access content of communications in other parts of the world. The United States really falls short with respect to regulation of private companies, and there is a huge divide between what the United States is doing and what, for example, Europe's doing in this area. And I think it's an area where the United States really ought to think about doing more, and actually is going to be forced to do more because the regulations in Europe cover any entity that processes the data of European residents and requires certain protections to be in place before that data can be transferred out of Europe. And as we've just talked about, these companies are transferring data around the world for a variety of reasons all the time. So the European regulations are going to at least force in some limited ways some improvements, I think, on this front, or at least some additional requirements that the companies must follow. But I think there's a lot more that the United States could do and that we should be thinking about in this regard.
There's a fair case to be made that the reason I got here tonight is because of Google Maps. I would have been really late if not for that wonderful product. And Google Maps is, I'm rather certain, cross-subsidized within Google from their advertising, very profitable advertising program. So if you don't want to hear from me, maybe you do want regulation of ISPs' access to email and advertising based on what they get. But if you do want to hear from me, you can thank Google Maps. I want to riff on that question, though, and talk a little bit about ISPs and email with respect to the Fourth Amendment and our newest justice on the Supreme Court, because I was very interested by a case that he decided. He wrote recently in the 10th Circuit called U.S. v. Ackerman, or Ackerman v. U.S., I forget. This was a case about email. In the case, AOL, just like most major email providers do, was checking in an abstract way the content of attachments, running a hash on attachments to emails and checking the hashes of those attachments against a list of known child pornography materials. This is a way of trying to keep child porn off of their systems without having to require someone to look at images and so on and so forth. They discovered that there was a suspected or probable item of child pornography and sent it over to the National Center for Missing and Exploited Children, which for purposes of this case is a state actor, so is essentially the government. And NCMEC opened up the email and not only the suspect attachment but two other attachments and examined them and found that these were indeed criminal to possess and commenced a prosecution of this guy Ackerman. Now Justice Gorsuch wrote the opinion in that case, and I like the way he thought about these things in the opinion, because I think it's clear from the opinion that he presumed, he didn't say unfortunately, but presumed that an email is within the subject matter of the Fourth Amendment. I don't think it's a house. I'm pretty sure it's not a person. So it's either a paper or effect. That's implicit. And there's one other circuit court that has found that email is the modern scion of tangible mail. That's exciting and that's important. That's the Second Circuit that has found that email is a constitutional effect or constitutional paper. And then he recognized that opening an email file, AOL had not done this. AOL had not looked at the file. They had hashed one attachment and based on that sent the EML file over to NCMEC. They opened up the file to read the contents of the email, to look at what the images were. He recognized that that was a search. That was taking that data, which revealed nothing as data, ones and zeros or however it arrived with them, took it and made it into something human readable. That was a search. That had that purpose of finding something that you might use to administer the search concept. So now you've got a paper or effect. You've got a search of it. Was it reasonable? Well, no, there was no warrant. And that's what he found in Ackerman. The Ackerman case is back with the lower court to see if he can still be convicted. But that was now Justice Gorsuch, who I think was treating this technical matter in a way that is going to be very good for Fourth Amendment administration if he gets a say on it in the court.
Chris?
Yeah, I took that question to be about private companies reading our email or listening to our phone calls, and that is prohibited. What the ISPs are doing now, and maybe was really the trigger for this question, is they're collecting all of our metadata, the URLs that we visit, the people we call, the people we email. And they're keeping that maybe for advertising purposes, maybe for other purposes. And I think Jennifer's absolutely right. We don't regulate that at all. In fact, Congress just passed a statute that unregulated it. The Obama administration had tried to regulate it at least to some extent, but now basically it's no holds barred. The ISPs will be able to collect all of this metadata information for their own purposes. And then from my perspective, that is a perspective of regulating government, what that does is provides a treasure trove to government officials who now can access it as of right now under the third-party doctrine with no justification whatsoever as far as the Fourth Amendment is concerned. Now, there might be a subpoena requirement or something like that, but there's no warrant requirement in those situations.
Excellent. So we have time for maybe one or two more questions. Here's one that goes back to Jeff's keynote at the beginning. Jeff said that judges get protective of privacy when they can easily imagine issues affecting them. Given that federal judges are less likely to be from vulnerable groups, poor, non-white, et cetera, what are the implications for their ability to protect vulnerable Americans' rights? And I guess the flip side of that would be, are there any sort of advanced technologies that are developing that would not be in their ordinary use that perhaps threaten privacy, but because they are not exposed to them, they may not recognize the depth of the threats?
I think Jeff's point is great. I mean, that one question by Chief Justice Roberts was extremely revealing. I think he's absolutely right. The justices are more likely to find a privacy invasion when they can visualize it being their privacy that's invaded. Another case along those lines was Riley versus California, where the Supreme Court, to the surprise of many people, require police to get a warrant before a cell phone can be searched, even if the cell phone's found on a person who's legitimately been arrested. Most people thought that if the police have probable cause to arrest someone, they should be able to search what's on that individual's person, at least for evidence that's relevant to the crime of arrest. But the Supreme Court said, no, you need an independent warrant in order to search that cell phone. What's going on there? Every Chief Justice, with the exception of maybe Breyer, who doesn't seem to know how to use a cell phone, has one, and therefore was very concerned about this kind of thing. Another example of this kind of situation is actually relevant to the Constitution Center. Jeff mentioned the exhibit about prohibition. Prohibition produced a lot of the Fourth Amendment law that's relevant to us today. Why? Why was the Supreme Court so concerned about the Fourth Amendment during Prohibition and adopting the exclusionary rule, which, as you probably know, excludes evidence that's illegally seized? One possible explanation is Prohibition affected the justices on the court. It did not involve street crime, rape, robbery, or murder. It involved the kind of crime that their friends might be engaged in. And so they were much more finicky about search and seizure when those kinds of cases got to the Supreme Court. So it's an example of what Jeff was talking about. The future kinds of technology that might apply to justices are, we've already mentioned some of them, some of these data mining programs that the government is developing day by day that are accumulating huge amounts of information. I think the justices are starting to sit up and take notice, that the decisions back in the 1970s about getting a single phone call or finding out about one day's worth of bank records are no longer relevant to what the government is doing today in terms of the amount of aggregation of our personal information that's going on.
And I've just, on the Riley case that Kris just mentioned, I think it's a really important case. It was 9-0. And in that case, the justices basically said, it would be like if you found a key on somebody's body and said, therefore, you could go to their home and open their door. So it was a recognition of the fact that our phones carry with us so much information, all kinds of information that we used to store in our home, a protected space, and that we need to not just kind of blithely adopt the rules that formally apply, that if you search somebody, you can arrest everything on their person, but to recognize the difference of data and our digital devices. And I think that was a really encouraging opinion in terms of the justices' awareness that something is different here.
I love that you remember that from the Riley case, that reference to the key, because I briefed the court as an amicus in that case, and its companion case was called Worry. These two cases were combined and decided as Riley. In Worry, W-U-R-I-E, law enforcement had taken keys, in addition to a cell phone, had taken keys from their suspect. And they used the keys to enter the apartment building of the suspect and to open the door of the suspect's apartment, behind which was a woman and her baby. They didn't go inside. They just opened the door to confirm that the key related to this particular location. I noted that and sort of emphasized it in my brief because I wanted the court to recognize how invasive that was. That just the fact that you've taken something from someone doesn't make it a tool you can go and investigate. So I wanted them to get that the key, they're not allowed to open a door just because they got a key, and they're not allowed to look into a cell phone just because they grabbed it off of a suspect, which they can do, to prevent destruction of evidence or to prevent it being used as a weapon. They can't just look into it because they grabbed it. But that key, this is the minor hook where I think maybe I influenced the court because that was mentioned in the decision, but who knows? Back to the question of can the court rule, with the vulnerability of populations in mind? I haven't done the full study, but the Riley case was an African-American gangbanger. His car was red for a reason because he was a blood, and all the C's in his phone, like the entries for people with a C to begin their last name, it said CK. That's for Crip Killer. So this was a vulnerable population in a sense, not an attractive defendant by anyone's perspective if they are middle class, older, white male. But the court seems to not have cared about that. When I was in law school, I recognized very easily that there seems to be an illegal drugs rule, that whenever illegal drugs are ultimately found, it's reasonable to search for them. Now that's backwards, obviously, but it illustrated to me that courts don't always get this stuff right, don't always think rationally about it. I think it's an open question whether judges of seniority and rank in our society can think in judicial ways about the question of vulnerable populations.
Thank you for that. And sadly, we are running on overtime right now, so Kris, Jen, Jim, thank you so much. Please give our terrific panelists a hand, and thank you everyone for coming out tonight. Read the papers online and continue to engage with these really interesting issues. Thank you.